Welcome to today's webinar, Drafting in Plain Language, Leaving Legalese Behind, brought to you by NCSL. All lines have been placed on a listen-only mode to provide favorable sound quality during today's presentation. It is now my pleasure to turn the floor over to Kay Warnock. Ma'am, the floor is yours.
Thank you. Welcome to our webinar. This webinar is sponsored by the Legal Services Staff Section and the Research and Committee Staff Section, and it's supported by an NCSL e-learning grant. Over 200 registrants from 39 states are participating today. This webinar is being recorded and it will be posted on the NCSL website for the use of legislative staff unable to attend the presentation. Please watch for notice of our next webinar, Federal and State Preemption Basics, What Every Drafter Ought to Know, which will be held on Tuesday, July the 12th. You should have received an email with the 5 handouts for this webinar. The only handout that you might need during the webinar itself is the exercises. If you didn't receive the email, you can click the Media Library icon. It's up on the upper right-hand side of your screen, and it's a yellow piece of paper with a little blue piece of paper over the top of it, and you can download those exercises at this point if you need to. All of the other handouts are available for you both in that tab and also on the web page for the webinar, and you can use those later if you'd like to. We'll be taking questions at the end of the webinar using the chat box in the lower left-hand corner of your screen. Please feel free to type any questions in that chat box throughout the webinar if you need to. And so with that, I will move on to our speaker. Our speaker today is Debbie Haskins. She's the Assistant Director of the Office of Legislative Legal Services in the Colorado General Assembly. Welcome, Debbie.
Thank you, Kay. Welcome, everyone, to our webinar on drafting in plain language, leaving legalese behind. Let's start with a couple of famous quotations about how lawyers write. A sentence should never be cruel and unusual. William C. Burton, Chairman, the Burton Awards for Legal Achievement. But do not give it to a lawyer's clerk to write, for they use a legal hand that Satan himself will not understand. Cervantes. These are the topics we will be discussing today. What is legalese? Why should legalese be avoided when drafting bills? How can legislative attorneys and editors recognize and eliminate it? By following 8 plain language rules, legislative attorneys and editors can recognize and eliminate legalese in bill drafts and in existing statutes. And like our little corgis, we will use some exercises throughout the webinar to illustrate plain language principles when drafting legislation. So what is legalese? Here's a fairly neutral statement about legalese from Merriam-Webster's dictionary. But dictionary.com has a more negative view. It's legal jargon. And then Merriam-Webster piles on in its secondary definition, it's the language used by lawyers that is difficult for most people to understand. So if it's difficult for most people to understand, should we draft statutes with legalese? Generally, legalese is frowned upon by people who teach legal writing, but some people actually defend it, such as this gentleman, Jeremy Violin, who recently wrote in a blog, it's very important for attorneys to be well-versed in legalese. He says it must be practiced with care. Some people say legalese is necessary because it's a term of art. It conveys a special meaning in a particular context. For lawyers, it's a shorthand. It conveys a legal concept. Here are some examples of legal terms that convey a legal concept. When these words are used by lawyers, they immediately flash back to their days in law school, where they learned these terms by discussing cases under the Socratic method. When you find yourself coming across one of these legal terms of art, ask yourself, is a legal term of art really necessary? I would assert that there are times when using a legal term of art is really not necessary. Do we really need to say chattel when personal property is understood? Most plain language advocates assert that using a legal term of art is only necessary about 2% of the time. My observation would be that these are the kinds of terms you could use in a legal memo to communicate a legal concept, especially if your audience consists of other attorneys. But in cases of legislation, a bill drafter does not need to use and should not use these technical terms of art unless the legislation is in a very specialized area of law, such as contract law or a bill relating to bonds or certificate of participation. The problem with using legal terms of art is that lay people do not know what these terms mean. They didn't go to law school. The average reader will not understand your statute. When we sprinkle a statute with legalese without defining the term, or when we string a combination of legal terms together, we lose our reader, and then the reader won't understand what is meant. Our goal in bill drafting should be to write legislation as understandably as the subject matter allows. Let's take a poll. What level of comprehension should legislative drafters strive for when drafting legislation? So while we're waiting for the results to come in, I'm going to give you a few more quotations. One should aim not at being possible to understand, but at being impossible to misunderstand. Quintilian. The letter I have written today is longer than usual because I lack the time to make it shorter. Blaise Pascal. Looks like we're starting to get a consensus on the results. Most of you are selecting B, 8th grade level, which is very good. That's the answer I wanted you to select. The general advice on readability is to strive for 8th grade comprehension. The reason for this is that if you write at the 8th grade level, the average constituent or the average reader will be able to understand the law. If you write for a higher level, you will lose the understanding of your constituents or readers. And if you write at a 3rd grade level, you will be talking down to your audience. Let's take another poll. So this question is, why should legalese be avoided in drafting legislation? Think about a person who is representing himself or herself as a pro se defendant. How is that pro se defendant going to understand the statute? Here's another quote. The language of law must not be foreign to the ears of those who are to obey it. Learned hand. And a person from my English background, the biggest problem with communication is the illusion that it has been accomplished. George Bernard Shaw. Well, the consensus is in. 96% of you have selected all of the above, which again is the answer I was hoping that you would select. Legalese is more than just using legal jargon. It isn't just the use of legal terms that causes problems. Many of the problems caused by ambiguous statutes are due to poor writing construction. If we follow good standards of writing, our legislation will be improved. When we fall into sloppy habits and write in passive voice and use too many words of legal jargon, our legislation falls short. When we write like we want everyone to know we went to law school, our legislation falls short. There is an alternative to legalese. It's called plain English or plain language. Legislative attorneys and editors can recognize and eliminate legalese when drafting and editing legislation by applying plain language principles to their bill draft. The 8 rules that I will be going over in the webinar are adapted from this book, Plain English for Lawyers, by Richard C. Wydick. The exercises are based on statutes that I have encountered in drafting bills for the Colorado General Assembly. One of the advocates for plain language is former Vice President Al Gore, who said, "Clear writing from your government is a civil right." One of the handouts gives a brief timeline of the plain language movement. The hallmarks of plain language are these: to have clear, logical organization, to use common, everyday words except for technical terms, to write in active voice, to use short sentences, to use you, Y-O-U, and other pronouns. Under plain language principles, federal agencies now write their rules and manuals using you instead of in third person. I don't believe the use of you is appropriate in legislation, but the other ideas from the plain language movement make sense. My goal with this webinar is to apply plain language principles to the legislative environment. When I started researching legalese and plain language resources, I found that there were many materials out there on plain language, but very little advice on applying these principles to drafting state legislation. So let's turn to our rules. Rule number 1, omit surplus words. Richard Whitehead gives an example in his book about fine wood cabinets. He writes, "A well-constructed sentence is like fine cabinet work. The pieces are cut and shaped to fit together with scarcely any glue. In a sentence, there are working words that carry the meaning of the sentence and show the action. Those are key words or working words. Then there are glue words such as the, of, and a, which are the connecting words. Whitehead's advice is to eliminate the extra glue words that aren't needed. He says when you find too many glue words in a sentence, take it apart and reshape the pieces to fit it together tighter. The point is not to eliminate the glue words altogether because they do serve a useful purpose. The point is to pare the glue words down to only those that are truly necessary. In this example, the working words are underlined and the glue words are italicized. Now let's start editing. And I do need to make a comment here, and that is that the software that we are using does not show the text stricken. So the words that we want to delete are shown in brackets and in red, but on your handout, if you print them out, they will be shown stricken. So with our editing here, we can delete in the event that and replace it with if. The objection is really an objection to the complaint. So the filing of the complaint is wordy, and that can be eliminated also. In his discretion is also unnecessary and wordy. You've already said it is permissive by saying may file. That's all you need to say. A responsive pleading indicates that it is a filing in response to the complaint. So subsequent to the filing is also unnecessary and wordy. So here's the final version, and this has been edited from 27 words to 14 words. Here's another example. Let's start editing. The things that we want to delete are shown in red and in brackets. Those are unnecessary and can be eliminated, and the new words are shown in capital letters. So in this example, is empowered gets changed to may, so the Attorney General may appoint. Such, before the word personnel, is an unnecessary glue word, and it can be eliminated. As may reasonably be required is unnecessary and can be replaced with as needed. So the final version reads like this. The Attorney General may appoint personnel as needed to carry out the office's prescribed functions. And Whitehead has this little, let me get that back. When in doubt, cut it out. Now there's a corollary to omitting surplus words, and that is to avoid doublets and triplets. What's a doublet? 2 words. So instead of saying null and void, say void. Here's a triplet. I give, divide, and bequeath. Say I give. That's sufficient. And here's a historical note. Whitehead explains that the use of doublets and triplets comes from the days when lawyers in England needed to make themselves understood to both the court, which used Latin, and the common folk who used Old English. Courts and attorneys felt that using both words enhanced clarity, so they would combine both the Latin and the English terms together. The same thing happened with French and English terms. The courts were using French, and the common folk were using Old English or Middle English. So in this example, free and clear comes from Frio, Old English, and clair, Old French. Another factor is that the French put the noun in front of the adjective, giving us phrases like fee simple, attorney general, court martial, accounts payable. So I say to the wordy French, merci. Rule number 2, use action verbs, not nominals. A nominal is a verb that has been changed into a noun. Another way to say this is to say avoid nominalization. So nominalization is where the writer changes the verb into a noun. In this example, assessment is a nominalization of the verb assess. Instead of performs an assessment, go back to the verb assesses. Try using an action verb. Now you try. Here is an exercise for rule number 2. Eliminate nominalization. This is on your handout of exercises. So I'll give you a little time to look at this, and you can mark it up on this handout. So again, what we want you to do is to eliminate the nominals. Here's the answer. The teacher reviews the circumstances instead of the teacher conducts a review of the circumstances. The principal determines how to measure instead of the principal makes a determination how to measure. Rule number 3, use the active voice rather than the passive voice. Here are some tips for spotting passive voice. In passive voice, the object becomes the subject, and the subject, the doer of the action, is ambiguous. Usually you can't find the actor, or it disappears, or it moves to the end of the sentence in a by phrase. In other words, something is done by somebody. And the verb usually uses the form of to be with the past participle. Okay, so what's a past participle? I looked this up in one of my go-to resources for my days as an English major, the Little English Handbook, Choices and Conventions by Edward Corbett. A participle is a word that is formed from a verb, but that functions as a functions as an adjective. The past participle is formed by adding ed or en to the base form of the verb, or it may be the result of a special spelling. So here's an example. Pull, ed is added to the verb pull. Eaten is en is added to the verb eat. And then there are words of English language that don't follow those rules, and they have their own special spelling. That's one of the reasons why it's hard to learn English. So left, L-E-F-T, and bought are examples of those. And then a past participle expresses past action, and it's passive voice when it's combined with the verb using a form of to be. So for example, the report has been filed is written in passive voice. If you are used to writing in passive voice, it can be really hard to break out of this rut. It can sometimes be hard to even realize that you are writing in passive voice. So here's my tip. If you see the word by and the verbs written with the word to be in it, the sentence is probably written in passive voice. When I finally internalized this tip, I became able to identify when I had written something in passive voice. This example shows how you can convert passive voice to active. The key difference in active voice, the subject of the sentence, think of it as the actor. The state board does the action. It adopts the rule. but in the passive sentence, the subject of the sentence is the rule, and it is acted upon by the state board. So the tip here, when you see passive voice, ask yourself, who is the actor, what is the action, and what is the object of the sentence? If you can focus on those things, then you can figure out how to rewrite the sentence into active voice. Here's a second exercise. This is also on the exercise handout. I'll give you a little time to mark the passage. So one of the things you need to look for is whether you can find the actor. And do you see a verb form of the shall be? Okay, so here I've shown the words to be deleted in brackets and in red letters, and the new language is added in capital letters. Now, note that this statute did not explain who the actor was. By reading the context of the statute in which this sentence appears, which I have access to and sorry you don't, I have determined that the affected department is defined for that statute as a department. It's actually the Colorado Department of Public Health and Environment, but we have a short form definition and we just refer to it as a department. So in my editing, I'm going to put in the actor. I'm going to say the department shall update rather than the standardized document shall be updated annually. There's your passive voice. And I've also replaced the phrase but need not be limited to with shall include at least the following. So this is more clear and it's written in the positive rather than the negative. So let's, there we go, comment. Okay, rule number 3, here's another exercise on your sheet to make this active voice. And notice the future tense of this section is written with a shall be. And remember, any form of to be is a clue that something is written in passive voice. And also there's a him in this passage. While we're at it, let's make this gender neutral. So here is the edited version now in active voice. The words to be deleted are in red and in brackets, and the capital letters show the words that we have replaced. So the Attorney General shall be the legal advisor rather than the Attorney General is the legal advisor. Shall have this changed to has control. And then notice I rewrote this last sentence. So as a general rule, it's recommended that you not start a sentence with the word no. Better to recast the sentence and place the not next to the verb receive. So instead of saying no member of the Attorney General staff shall receive any payment of state taxes and so forth, say a member of the Attorney General staff shall not receive any payment of state taxes. Now, passive voice is not always wrong. It is advisable to be cautious in eliminating passive voice when you are making changes to an existing statute, either in legislation or if you are making changes on revision. There may be very good reasons to keep a statute in passive voice, where the actor's identity is unknown, where there are multiple actors, and it would be difficult to determine the proper actor. So I want to give a comment here. If you as the drafter or editor guess incorrectly about what was intended, and you are making a drafting change to fix the grammar without being specifically directed to by your bill sponsor, as a drafter or editor, you are making a policy choice and substituting your own judgment for that of the original drafter or that General Assembly that passed the original legislation. Another factor is that sometimes legislators intentionally draft legislation to be vague, what one of our Colorado legislators refers to as, quote, land ambiguity, unquote. It's a grand compromise to pass legislation was to have it be ambiguous. And 10 years later, a legislative attorney or a code reviser comes along and picks an actor that's wrong, or undoes that planned ambiguity, that might cause problems. For instance, how should this passive sentence be amended? Here we have an example of a statute that is in passive voice. I'll give you a little time to read it. So this is a statute about when death occurs and how you would determine that. The actor is not really identified. Who is determining that the individual is dead? A police officer, an EMT, a doctor, a coroner? As you can see, there are multiple possibilities. Should the drafter insert the actors? What if we leave somebody out? And looking at the other section that's referred here to, section 1236, 136, doesn't help either. It's also written in passive voice without clear actors. So I would submit that this is an instance where caution should be exercised, and leaving this in passive voice is the right choice. Rule number 4, use short sentences. So I'm going to illustrate rule number 4 by showing you what not to do. There is too much jammed into this one single sentence. It's almost incomprehensible. How do we know there's too much information jammed into this section? In WordPerfect, you can do a word count. This one sentence has 196 words. It contains at least 6 different criminal acts. Frankly, it would probably be better if this was subdivided into different segments. Now, that might not eliminate 196 words, but it would probably aid in comprehension. So while we're talking about subdividing a statute into segments, let's go over a few points about how to do that. So what I'm talking about is dividing this into an introductory portion, so putting a subsection 1 before the word any person, and having an introductory portion, any person who does such and such, and so then you would have parallel paragraphs A, B, C, and so forth. So when you're doing that kind of a subdivision, first be sure that every paragraph or unit under that introductory portion fits with the text of the introductory portion. You should read every introductory portion with every unit that follows it. Does it make sense? Test it. Consider reading it out loud. Sometimes hearing it audibly will help you with your editing. Second, write each of the paragraphs or units under that introductory portion in as parallel a fashion as you can. That aids in comprehension and consistency. And third, be careful and very thoughtful about whether you should use an and or an or between the subdivisions or units or between the second to the last subdivision. It will also depend on what you say in the introductory portion. Again, you need to test this as well. So back to this passage, I've color-coded 6 different prongs of the statute. When a statute is written in this way without separating out the different elements of the crime, it becomes incredibly difficult to understand or to amend in the future. This statute covers crimes involving vital statistics certificates. Based on the definition of vital statistics certificates, this statute covers crimes involving death certificates, birth certificates, and certificates of stillbirth. I worked on legislation last year where the legislator and the contact people wanted to add a crime of misrepresentation of material information on the birth certificate. It was a narrow crime covering only birth certificates. We tried to fit this new crime into this incredibly complicated statute, and at one point tried to rewrite the statute to make it more clear. But we finally abandoned the effort to clean up the statute to make it more clear. But because of single subject concerns with the bill title. We have a single subject requirement in our state constitution, which affects what we can put in legislation. Finally, what we ended up doing was creating this crime in another statute and making a cross-reference in this statute. The amendment added an exception at the beginning of this section. With the new language, the statute now reads, except as otherwise provided for in section blah, 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 with respect to misrepresentation of material information in the preparation of a birth certificate, any person who knowingly and willfully, and so forth, so on. It was the best we could figure out to do at the time. Sometimes you are limited from what you can do to rewrite existing statutes by factors such as the single subject rule for bill titles, the difficulty of determining how to fix something, and the limitations caused by existing definitions. The result is that this overly complicated statute did not get rewritten last year, and it became even longer. It's longer than 196 words now. After this webinar, we are going to run a contest for the participants of the webinar to see who can rewrite this passage in the clearest language. If you want to participate, open up a handout labeled exercises, copy and paste this exercise into your own document, rewrite it, and then send an email to me at debbie.haskins@state.co.us with your rewritten passage. I will share the best examples with our participants by email. Rule number 5, arrange your words with care. So go back to what you learned in school in English composition. Follow the normal word order for writing English: subject, verb, then the object. Writing that doesn't follow standard English makes it difficult for your reader. What we find is that writers often have made expansive leaps between the subject and the verb and the verb and object. Try not to split those up. Here's an example where the statute does not follow the normal word order. I've color-coded the words by different types. Now note that I haven't color-coded every type of word that is the same. I've color-coded the most important of the words to illustrate the point. So the key subjects are court, agent, and claimant, and they are in red. The key verbs are shown in blue, and the key objects are shown in purple. Note the verb form shall be destroyed is split up with a parenthetical after entry of the decree. That's not recommended, but this is very common in statutory drafting. It can't always be avoided, but try. In the second sentence, note the phrase shall be cast. It's written in future tense. So how can you write this in normal English word order? The best way is to arrange the sentence, is to break it up into multiple sentences and write those sentences in subject, verb, then object format, and put it in active voice. So here is the rewritten passage identifying the subject, in other words, the actors, in red, the verbs in blue, and the subjects in purple. And note now that it's really clear who does what. The court shall order the destruction. The agent shall destroy the adulterated or misbranded article. The claimant must pay to the agent the court costs, fees, etc. It is much clearer now. Another corollary to arranging your words with care is to be careful with the placement of prepositional phrases. Misplaced prepositional phrases can also cause trouble. I'll give you a minute to read this passage. The prepositional phrase is highlighted in red, and it is at the end of the sentence. It is in the example. So with the victim as defined in section 24.4.4-302 CRS. That's confusing, isn't it? So let's move the prepositional phrase to its rightful place, and it's much clearer. Rule number 6, use familiar concrete words. What Wydick means when he says to use familiar concrete words is what drafters refer to as using words based on their common usage. Remember the rule of statutory construction, to use words the way they are commonly used. Here's Colorado's version. Most states have a similar statute. Don't send your reader to the dictionary, or if it's a technical term, define the word in a definition section in your statute or bill. Maybe your state has statutory definitions for all of your statutes. Remember and use those definitions. Let's take another poll. Vote for the better word choice. So our first one is between utilize and use. And let's see, some more votes are coming in. Yes, everybody's picking use. Very good. That's my choice as well. Okay, so our next set of words goes between tasked with and required to. Okay. Very good. Yes. So looks like everybody's selecting required to. Very good. I would agree with you. I absolutely detest tasked as a verb. And then now our final choice between within and under the provisions of and in. So yes, we've got some votes coming in here. Okay. Oh, you're a very good audience. That's the one I would choose too. I love this last example because we have replaced 6 words with 1. And here's another quote from James Kilpatrick. Use familiar words, words that your readers will understand, and not words that they will have to look up. No advice is more elementary, and no advice is more difficult to accept. When we feel an impulse to use a marvelously exotic word, let us lie down until the impulse goes away. Okay, let me just click through our words here on our screen. Sorry about that. Okay, now we are ready for our next screen. Really, these archaic words are obsolete and unnecessary. This is pure legalese. Edit these words out of your legislation or use the suggested substitute. Rule number 7, avoid language quirks. So this is another drafting principle that we should use terms consistently. But Wydick refers to this concept as avoiding elegant variation. So why avoid elegant variation? Multiple variations for the same thing as ambiguity. A rose is a rose is a rose. Call it a rose. More language quirks, avoid multiple negatives. So here we have, it shall be unlawful to fail to stop at a red light on a traffic signal. Let's rewrite it in the positive. A driver who fails to stop at a traffic signal with a red light commits a traffic offense. So note, we've eliminated passive voice, and we've specified who the actor is, a driver, and we've gotten rid of the to be. Even more language quirks. Avoid gender-specific language. If you haven't already done this, start to make your statutes gender neutral. Use he or she, not he. Use gender-neutral terms. Replace fireman with firefighter. One of the handouts is an excerpt from the Colorado Legislative Drafting Manual. It gives our guidelines on how to write in gender-neutral language. Part of the handout includes common replacement terms. Our General Assembly and our office decided to implement gender-neutral drafting prospectively, so we change it only as we find it in legislation. This is a very common editorial change that our office makes in bill drafts. The decision was based on lack of resources to make the changes throughout the statute, so we change them only as we find them. And rule number 8, punctuate carefully in accordance with ordinary English usage. Now, due to lack of time, we are not covering this with examples or exercises. I know all those editors out there have their own favorite manual, but if you need one, you can see the resource list that I have prepared. And now here is my favorite bad statute. And I'm not kidding. This is in the Colorado Revised Statute. So this is a statute that's supposed to tell you how to figure out the residency of a child in a public school district. So it says, the child shall be deemed to reside in a school district if the legally appointed guardian of his person resides in the school district. Say what? The guardian of his person? What person are we talking about? The child or the parent or the guardian? And then look at 1F. I love this. We have two ifs in here. A child shall be deemed to reside in a school district if one of the child's parents or the guardian of his person is a public officer or employee living temporarily for the performance of his duties in a school district other than that of his residence. Again, what person are we talking about? The child or the parent or the guardian? The use of his is ambiguous because it's really unclear if we are talking about the child or the child's parent or guardian. Frankly, in the words from the movie Cool Hand Luke, what we've got here is a failure to communicate. I discovered this statute when I was doing conforming amendment searches to find references to husband and wife in the Colorado Revised Statute and other places where it was not gender neutral relating to parents. The project was based on changing these references to spouses, which is a more inclusive term given the new marriage equality for same-sex couples. If you were to change this language in a bill, how would you change this section when it's impossible to tell to whom the original statute applies? In addition, trying to change it could very likely be perceived as not fitting under the title of the bill under single subject requirements. My conclusion was that any attempt to clarify the statute would have crossed the line into making policy choices rather than just being a conforming amendment. And any attempt to figure out what policy should be would have required lots of conversation with the Department of Education. This is the second exercise for the contest. Again, if you want to participate, open up the handout labeled exercises, copy and paste this portion into your own document, rewrite it, send it to me by email with your rewritten passage, and Kay and I will share the best examples with the participants by email. And now we are to our final exercise with another poll. What things are wrong in this particular passage? And note there are four choices here. So I'll let you read through that, think about that. And I have a quote now for the legal editors out there. No compulsion in the world is stronger than the urge to edit someone else's document. H.G. Wells. So people are still voting, although it's looking like most people are selecting the same answer. So I think this audience is very smart because you are picking the answer I would have picked, which is B. The correct answer is 4. Here is the passage edited to follow the principles discussed in this webinar. Again, the words that are in red and in the brackets are what we are deleting, and the new line is shown in capital letters. So this passage was written in passive voice. The clues are the letter of admonition is sent by the director. Something is being done by somebody. There are examples of forms of to be. Such recipient shall be advised. He has the right to request that formal disciplinary proceedings be initiated. So we've rewritten this to be an active voice. Another flaw in this section is that it uses the term registrant and recipient for the same person. Again, this is an inconsistent use of terms. Remember, a rose is a rose is a rose. Use the word rose. It also uses vague and necessary words like such, so that can be eliminated, and it was not in gender-neutral language. So we are at the end of our webinar. I have one more passage for you, one more quote. Vigorous writing is concise. A sentence should contain no unnecessary words, a paragraph no unnecessary sentences, for the same reason that a drawing should have no unnecessary lines and a machine no unnecessary parts. This requires not that the writer make all his sentences short or that he avoid all detail and treat the subject only in outline, but that every word tells. William Strong and E.E. White. So we've reached the end of the webinar. If you want to submit answers to the contest on improving the badly written statutes, send them to me by email. By June 1st, Kay and I will send out the best examples by email to everyone who has participated in this webinar, and I guess we'll post it on the homepage. Anyway, Kay and I will work out the details on that. I also want to thank Jessica Wygant, who helped me to create this PowerPoint, and I want to thank Kay Warnock, who helped me produce this webinar.
Thank you, Debbie. So now I'm going to open up the floor. If anyone would like to post any questions in the chat box, please feel free to do so right now. Also, please feel free to contact Debbie directly or contact me if you have questions that you'd like to ask offline. The chat box is pretty quiet. One of the things I loved about this webinar is looking at these really long sentences and finding ways to rewrite them so that they're clearer. I love that. It's definitely something that I try to strive for, and I don't draft legislation. I'm just trying to communicate with all of you. But making your communication clear is really important. So I love this. So it looks like there aren't any questions. So with that, I think we will conclude the webinar. I appreciate everyone for participating. Thank you so much. Debbie, thank you so much for putting together such a great presentation and all of the great handouts that go along with it. Again, as Debbie mentioned earlier, if you would like to participate in the contest, and I will tell you we've already had one entry in the contest, so get your entries in. We would love to see how you do your rewrites. Thank you very much and have a great day.